Good evening. I'd like to start our nice lecture of today, and it's dedicated to artificial intelligence and different angles of artificial intelligence. And let me introduce Dr. Paresh Kathrani, who is our strategic consultant in Mykolas Romeris University, and he is helping us with the legal tech solutions and a legal tech centrum. And it will be a pleasure for us to listen his lecture. Dear Paresh, please.
Thank you very much, Paulius, for that introduction, and thank you very much, Aquile and the Law School for organizing today's masterclass. I assume you can all hear me, so I will get started. Well, first of all, good evening to you all. My name is Dr. Paresh Kathrani, and I am a strategic consultant, as Paulius mentioned, working both at the Legal Technology and Innovation Institute based here in London, and also the Mykolas Romeris University Law School. I've now had the pleasure of working with the law school for the past year on a number of its programs, including the bachelor's program in law and global security, the master's in international law, and also Paulius's course, the LLM in legal tech. If you haven't yet had the opportunity to look at these programs, then I would strongly encourage you to do so. I'm delighted to have been asked by the university to deliver this masterclass in a field that is very close to me, namely technology and law. My interest in technology and law goes back to at least 2012, when, together with a group of colleagues from the University of Westminster, we created serious games for the purposes of teaching students law. This included a prototype virtual reality game in which students were immersed in a murder scene and had to navigate the virtual environment and interact with avatars in order to establish if the actus reus and mens rea of murder had been committed. You could indeed call this the forerunner to today's metaverse. One of the difficulties we had back then was programming the avatars with all the different combinations of language inputs with which it could be faced. One student at the time may have said, do you have an insurance policy? Versus another who may have asked, did you take out life insurance? So there were a multitude of different ways in which the students could have interacted with their avatar. I recall back then having to think about the myriad of different ways in which one could say hello. Hi, hey, hello, how are you, etc. All of these had to be programmed into the program in order to ensure that it ran successfully. As you will see, by the end of today's masterclass, this no longer represents a problem. My interest in technology and the law grew from then, and since then I have researched, written, and talked about a diverse set of topics, from the impact of AI on the legal profession to the regulation of digital money. I come now to technology. You will see that throughout my talk today, I refer to many Google definitions, which ties in nicely with my theme on the coming together of advanced technology and language. I typed in define technology into Google, and it came up with the application of scientific knowledge for practical purposes, especially in industry. And this application of scientific knowledge can be both exciting and terrifying at the same time. Exciting because I can now see the latest films on my tablets without having to leave my sofa. Terrifying because no one quite can predict what the impact of technology will be. In recent days, the news has been filled with stories of ChatGPT and GPT-4, advanced AI systems that can provide solutions to complicated problems using large language models. And many industries are now experimenting with the application of this technology, including the industry of law. One can understand the questions that such systems raise. Today, I'll be looking at the effect of generative AI systems that can generate new content on the basis of data on legal practice. And in doing so, throughout the course of my presentation, I will make a few assumptions. The first assumption. Some of the audience may be experts in artificial intelligence, and others may not have the same level of knowledge. As such, I introduce some of the basic models of AI.
Dear Paresh, sorry to interrupt. Are you moving with your slides? Because we see just the initial first one.
No, I'm just an introduction. I'll be moving my slides in a couple of minutes.
Sorry.
No problem at all. I'm just making an introduction now, but I'll be coming to my slides in a couple of moments. So my first assumption is that some of the audience may be experts in AI, and others may not have the same level of knowledge. As such, I introduce basic models of AI. My second assumption. Some of the audience may be experts, some of the audience may have a legal background, whilst others may not have a legal background. For this reason, I look at different systems and processes of law. My third assumption. Some of you may already know of the impacts of generative AI on legal practice, whilst others may not have come across generative AI and may not know what it is. In order to make the matter interesting and relevant for both groups, I've approached the subject matter of my talk today, from the viewpoint of legal language, as you will see very shortly. So I will bring all of these assumptions together in the course of my presentation by drawing upon and making reference to AI models, the systems and processes of law, which some of you may or may not be familiar with, and finally, what generative AI is and what large language models are. My last and final assumption is that this is a masterclass, and I should make it wholesome and rich. My masterclass will last for between 1.5 to 2 hours, with a break in between. And I'll be delighted to take questions and answers both throughout and also at the end. Please do feel free to post your question and answers as they arise in the chat, and I will do my best to answer them either as and when they arise, or if not, certainly at the end. I'll be delighted to answer your questions. I'm very grateful to you all for being here, giving up your evenings, and I very much hope to succeed with my final assumption of making this a wholesome and rich masterclass. I'm here to provide you with the best experience in terms of masterclasses, and I very much hope I succeed in that endeavor. I turn now to my slides and the masterclass, and I thank you all very much. So as I mentioned a few moments ago, I'm approaching this masterclass from the perspective of language. And in doing so, I hope to both appeal to those who know how generative AI works by talking about the language of law and explain the intersection of the language of law and large language models, and at the same time, explaining what large language models are to those who have no familiarity with these models. So in order to encompass both groups and talk to both groups, I am pitching this talk from the standpoint or perspective of language. And I'm talking about the law as a language. For those of you who are lawyers, and indeed for those of you who are not lawyers, I think we can all familiarize or identify ourselves with the law as a language. The law lays down various norms, different rules, which are of course made up of words, structured words that lay down what should or should not be done. That, as you'll see in a few moments when I come to the definition of language, is a language in itself. So the law lays down various rules that are composed of words in different structures in paragraphs. And from that perspective, the law can be seen as a language in itself. And working from this basis of the law as a language, throughout my presentation, and certainly towards the end, you'll see how large language models, such as ChatGPT and GPT-4, intersect quite nicely and work quite nicely within the legal field, because there is this intersection at the level of language between the law and these large language models, which will become apparent as I go through my presentation today. For those of you who are not familiar with ChatGPT and GPT-4, and indeed large language models, then there is a link on screen, or indeed if you go onto Google and you type in ChatGPT or GPT-4, you can access OpenAI and have a play around with some of these large language models, which are very interesting, and I would encourage you to do so. So I start my presentation by looking at law as a language and deconstructing what it means for the law to be a language by looking at legal language in the first part of my presentation. And what you'll see unfold throughout my presentation will be a series of different questions. So my presentation can be structured and broken down for your reference into the following main questions. Throughout my presentation, I will be addressing these 7 questions, turn by turn. And you will see these unfold as I go through my talk today. I'll begin by looking at, well, what is language from a conceptual level and from a definitional perspective? Having introduced what language is, I'll then look at what does that mean for the law as a language? Then, how does that translate into legal practice? How does legal practice then carry forward the language of law? I'll then address how that system of law has been changed by artificial intelligence. Then, what do large language models and generative AI do to those processes of law? What legal and other issues do they pose? And at the end, I'll leave you with a series of questions for you to consider. So by the end of my presentation today, I will have gone through each of these 7 things in turn, and that's how my presentation will be mapped out for you. And I will take a break at some point in my presentation, just before I introduce large language models. So you'll see each of these 7 questions unfold over the next hour and a half to 2 hours. I begin with, well, what is language? And here I typed in define language into Google, and it came up with the following definition of language. The principal method of human communication consisting of words used in a structured and conventional way conveyed by speech, writing, or gesture. That definition of language can be broken up into many different parts, as you can see there on the screen in front of you. And indeed, there are several parts within that definition that resonate with what the law is. The law is a system of communication, whether it be contained within codes, statutes, cases, as in the case of common law or elsewhere. The law needs to be communicated to people in a clear and concise manner so that they know, for example, what their legal rights are. Of course, there are also prohibitions against a retrospective punishment, so people need to know what the law is in order for it to apply to them. So language as a system of communication, we can already begin to see how law is ultimately a form of language. That definition of language also contained words. We can go into what words are, but I won't take too long, or indeed I won't even interrogate to any great length what words are. I think we all know what words are, but the definition of language contained words as a key component of language, and the law is of course made up of words as well, in a structured way, structured by way of sentence, structured by way of grammar, syntax, sentences, paragraphs. As well as I'll go through later on in this presentation, structure, patterns are an important component of language, and indeed an important component of the law. And this idea of conveying something and communicating to something is an important facet of language. So what we gather from the definition of language from Google on the previous screen is that language consists of many component parts: communication, words, structure, convey are some of the key parts which you see within law, within the language of law. I'll focus on words because, of course, the law is made up of words, whether it be contained in a code, a statute, within common law. Law contains words: you shall not, reasonable, fair, right, etc. We've all, certainly the lawyers, and if not, we've all come across the words of law throughout our different stages of our career. And Certainly, when I was teaching law to students as an academic, I referred to the concept of word mining. And what is it that lawyers do? They take statutes, or they take codes, or they take law, and they look at words within that law, and they ask themselves, well, does this particular set of facts, does this case come within the meaning of the legal meaning of that particular word? So, for example, the law might say something like it's reasonable to do X. Within there, what does the word reasonable mean? Did the conduct complained of, or does the conduct in question, was it reasonable? And so one needs to understand what reasonable means and ask oneself, well, does this particular fact pattern fall within that meaning of the word reasonable? Or if it doesn't, should it do so? And is there a case, for example, within common law jurisdictions, to go to court and argue that, well, the law needs to be extended, that word reasonable needs to be extended to encompass this particular fact pattern? So word mining is something which, of course, occurs within law. It's some would say it's the very industry of what law is, taking the law and arguing do fact patterns, do cases and circumstances fall within the meaning of those words. So we can begin to see how words are an important component of language, hence they're an important component of law, and what goes on within the law is effectively word mining that students are taught to do, to argue whether a particular case comes within the law, comes within a word, or does not come within the word. And we see that both within the civil law and common law jurisdictions, whether a lawyer goes to court and is arguing that a particular fact pattern, something within a case falls within a code, or indeed whether it falls within statutes or previous cases that might have been argued in higher courts with reference to common law, which looks at whether concepts and the meaning of legal words and whether a particular case aligns with a particular interpretation of a word within the law. And within this jurisdiction, and indeed within lots of jurisdictions, we have rules of statutory interpretation, formal rules that enable lawyers and others to interpret statutes. And so within England and Wales, there are certain rules of statutory interpretation that you might have come across before, such as the literal rule, that words of statutes should be interpreted literally. And then you have other rules such as the golden rule and the mischief rule, and other rules that you can, by all means, you can look at that enable us to interpret what the words within statute actually mean. So an example, if you wanted to look at a famous case of statutory interpretation from this jurisdiction, would be a case called Corkery and Carpenter, where legislation said that it was unlawful or to be in control of a vehicle whilst intoxicated. And the defendant in the case was in control of a bicycle. And the question was whether the word bicycle fell within the meaning of the word vehicle within the legislation. So what the courts did was they looked at the purpose or mischief of the legislation, looking at the mischief rule, the purpose for which the legislation had been enacted. And it had been enacted to ensure that people were not in control of vehicles whilst drunk, which is obviously wrong. And therefore they held that a bicycle was a vehicle and it was wrong to be in control of it, taking the mischief of the legislation or the purpose of the legislation into account. So what we're building up to is that we have a definition of language, and going back to the Google definition I gave earlier, one of the key components of language is words. Words are, of course, the bread and butter of, or the essence of what law is. Concepts that lawyers argue that their clients' cases or fact patterns fall within. And we have different rules of interpretation when it comes to those words. And so we can begin to see how what the law is from one perspective, or certainly from the perspective of words, is a language. And I'm not saying anything novel here. I mean, there are many different legal theories out there that, of course, talk to the law as language. Indeed, the very distinction, some would argue, very dichotomy distinction between natural law and positive law, one of it turns upon, from one viewpoint, words and language that natural lawyers tend to look at what the rules ought to be given various moral prescriptions and other theories of natural law versus positivists who, for example, might place a greater emphasis upon the words and language of law. So certainly there's a legal theory aspect to it, natural law, positive law aspect, but I'm not going to go too much into legal theory. But I think we can all subscribe to the idea that law is a language, certainly from a words perspective. So law as a language, I think we can all agree that, certainly from the viewpoint of words, that law is without question a language. Why is this important and relevant to my presentation? Because we can move then, if we accept that law is a language, it leads on quite neatly and helps us understand the law as a process. Because if the law is a language, then from one perspective, law as a process is the use and the control of that language in order to achieve certain ends. Let me go a bit more into that. And in looking at the law as a process, I'll introduce you to something that's quite popular here when we're teaching students law, called the Iraq process or Iraq method, IRAC. Some of you might have come across it in your own legal studies, and I'm not sure if it's something that's used within Lithuanian law schools, but you might be familiar with Iraq as a methodology for certainly for students for understanding the law, but it also applies more broadly to legal practice. So what does Iraq stand for? Iraq, IRAC, at the top we have so it's a process, a sequential process from I to R to A to C. And we can understand or analyze the law firm ecosystem, law firms and what lawyers do, and then we can look at what law students do, what lawyers do, what legal practice, what legal practitioners do, what judges do, from the viewpoint of Iraq, that they look at the I, the R, the A, the C. It might not be as linear as that. There might be feedback and other loops that go on, but there is something quite sequential to the way in which law works. So how does IRAC work as a process? So at the beginning, we look at the I. Let's look at it from a law firm perspective. The I, a client walks into a law firm. They then sit with their lawyer and they provide instructions on the basis of information. So at the beginning of the process, we have at least two I's, instructions. I'd like you to do something on the basis of this information. This is what's happened in my case. There's been a breach of contract, there's been negligence, there's been a crime, etc. That's what initiates. I can stand for initiation. That's what initiates the process. Then once the client's provided instructions on the basis of information, the next step would be R. Lawyers then research the relevant rules based upon that information. So if, for example, a client says that my mechanic did not repair my car correctly, and as a result, I suffered an accident, then lawyers might say, well, the relevant rules there would be the rules of professional negligence, or negligence might apply, broadly speaking, or breach of contract or so forth. But the information then at the second stage of R enables them to identify the relevant rules. Then the A, once the information has been provided and the rules have been identified, then the lawyers analyze the information in light of the rules. They apply the rules of law. They argue based upon what the law is. They advocate on behalf of their client by going to court and raising an argument in front of a tribunal, in front of a judge, and they seek to advance their client's case based upon the combination of the information and the rules. So there we have a number of A's: analyze, apply, argue, advocate, advance, and I'm sure there's other A's we can look at within that particular stage. And then finally, we come at the end of the chain to a conclusion where lawyers then, on the basis of the information provided, rules researched, case advanced, then provide concise, coherent, and cogent conclusions, whatever those conclusions might be, in meeting their client's instructions. So that's a process of law, although there might be many different processes. So what we have within this chain of Iraq, this process of law, is, going back to what I said before, a movement of language, a movement of words. So the part you see there in red can be looked at from the perspective of language, from the perspective of words. Moving words, words that move through the process, they might change as they go through the process, but what we have there is language that's introduced at the beginning and then flows through the system and then is changed until it comes out at the end. So at the beginning, when the client's providing instructions, they're obviously communicating to their lawyer, instructions on the basis of information, they're communicating to their lawyer in language what's happened. That language, those words can be in the form of oral, or indeed they can be written documents or evidence. But what is being communicated to the lawyer at the I stage is, of course, language and words. The lawyer then takes those language and words that the client then has provided them, and then looks at those in the light of other words, i.e., at the R stage, the words of law. So more words are introduced, and indeed, what the client has given is then commingled with the words of law. Certainly at the A stage, where there's analysis of the information, application of the law, advocacy, advancement of the case, then the words that the client provided at I, combined with the research that the lawyer might have done at R in order to advance the case. And then what's provided at the end by way of conclusion might be indeed something that brings those words together. For example, in transactional working by way of a contract, or indeed it might be a judgment provided by a court, having heard all the evidence. So you can see how, if we accept the premise that, which of course the language consists of words, that the law consisting of words is also language, then and that Iraq also brings in many words. You can see how language moves throughout there, i.e. the red lines, throughout that process of law, and how it is changed at many different stages. So from one perspective, say from the Iraqi perspective, Iraq perspective, what the process of law is the movement of information from one phase, the movement of words and information from one phase to another. We could look at this from something called a DIKW perspective that some of you might have come across. Indeed, you can Google it. D stands for data, I stands for information, K stands for knowledge, and W stands for wisdom, in the sense that data is introduced by way of documents and other forms of information, other bits of fact within the system. It's then coagulated into information. The lawyer then looks at information, applies knowledge to it, and ultimately wisdom in coming up with an answer. So there's many different perspectives from which that process of law can be analyzed as a movement of language and movement of words. What comes out of that system are other things. We can look at that from many other perspectives. What's happening within that ecosystem with the movement of words? We can look at it from a moral perspective, in terms of a client might walk in and say, well, look, I've been harmed and I've been injured. This is clearly wrong, and therefore the law should offer me protection. Not only is that a legal question, but it's also a moral question in terms of what's right and wrong, in terms of the way in which the problem's articulated and what's the wrong and right thing to do in that circumstance. So that can be looked at from a moral perspective. We could look at it from an authoritarian perspective, in terms of what distinguishes the law from other forms of prescription is, of course, the authority of law. So we can look at within the system what the authority of law brings to the analysis of the information that the client provides. We can look at it from policy perspectives in terms of achieving public goods. We can look at it from an economic perspective in terms of weighing up different values and achieving the fair allocation of resources, for example, social well-being. And some would argue from the perspective of power. Power provides an interesting perspective to look at it, because certainly from an adversarial perspective, then the way in which cases are fought, the way in which they're presented, the way in which their advocacy is advanced, there might be elements of power that come into that particular equation as well, depending on resources and so forth. So that model that I've just presented to you of language traveling through a system can be looked at from a multitude of different viewpoints as we look at the law as a system of language. So over the past few slides, what I've been looking at are a number of things. What is language? What are the components of language? One of the components is words. We see words within sources of law, within codes, within statutes, within common law. In many ways, industry of law is the mining of words, from one perspective, certainly. And what the processes of law do, the RARC processes, that they take those words in many different forms and they push them through a system with a view to coming to a conclusion, whatever that conclusion may be, whether it be a contract or a judgment or a piece of advice and so forth. So we can look at the process of law as a movement of words. But going back to the definition of language, words wasn't the only facet of language. So we turn back to the definition of language. And language being the principal method of human communication consisting of words, but also used in a structured and conventional way and conveyed by speech, writing, or gesture. Another important aspect of that definition is structure. So let's focus a bit more on structure, because certainly we can identify with the law in terms of words, but let's take structure from the definition of language and also apply that to the language of law. So here I want to spend a few moments on structure. So I could say to you that it was raining, so I decided to use my umbrella, versus use raining my I so was to umbrella it decided. Same words, different structure. Clearly one makes sense whilst the other does not. I could also say to you, it was raining, so my umbrella decided to use me, but I won't say that. So we glean meaning from structure. We, by way of grammar and syntax, we've learned over our lifetimes that words presented in a certain order, in a certain structure, communicate things in a certain way. Of course, we can communicate the same thing using different words in different structures. And we can also gather meaning from unstructured sentences as well. If I said to you, raining my umbrella I took, versus I took my umbrella because it was raining, one might appear unstructured, but you still understand from the first sentence why I took my umbrella. So we can certainly gather meaning from unstructured, what we might call unstructured sentences in which the words might not appear in the right structure or the right order. But sentence structure and presentation also have an effect on impact and communication and clarity. So here we think about things like poetry, philosophy, books, originality, etc. I think it goes without saying that the same phenomena, the same things can be communicated using different words, different structures, and the impact is different given the way in which things are presented and structured. So structure is also an important aspect, of course, of language. And there's something intentional about structure, in that when we're talking to people, or indeed when we're writing, we do so in a way that communicates our intentions or communicates what we wish to communicate with in the most clear, concise, and optimal form to achieve the impact that we want to achieve. So there's something quite intentional in the way that we talk, we write, and the way in which we arrange words when it comes to structuring our sentences and our paragraphs. And one could say that there's a very close relationship there between the intentionality of what we do, and not just the intentionality of action, and the intentionality of words and language and intelligence. Think about, for example, when you're talking or when you're writing, and what the thought processes that are going through your head at the time. Whether instinctively or whether you're thinking about it, when you're structuring your writing or your the way in which you talk to people, you're displaying intelligence in your intentionality in the way that you structure things to achieve the maximum impact. So there's almost a calculation that goes on within people's minds when they're presenting something, and even when they might, for example, be talking in anger, or they might come up with something without even thinking about it, there's still an element of having learned in the past about how something should be communicating it, and then applying that, even in that fit of anger, in a way which might not seem intelligent, but yet still draws upon what they've learned in the past. So there's a strong relationship, of course, between language, structure, intentionality, impact, and intelligence. And I'll come to intelligence. What do I mean by intelligence in that context? So here I'll continue with Google definitions and look at the definition of the word intelligence. And Google defines intelligence. Intelligence is the ability to acquire and apply knowledge and skills. And there we can pick out features such as ability, acquire, and apply. So intelligence is about capacity, it's about ability, it's about it being able to display or do something, able. We can go into different connotations or meanings of able, but it's that someone can do something. Okay, we can break it up philosophically, but I won't do that for the time being. It's about acquiring. It's about not just the ability to do something, or indeed not to do something, but it's also that ability stems from having acquired something in the past, having learned something in the past, and there's almost like a reflexive element to it. And it's about applying. So a link between ability and doing or not doing, having on a basis of acquisition of knowledge and the application of it. So there's a reflective component to intelligence. We can pick out application there, and within it, the definition of intelligence, apply is an important word. Please excuse me. Apply is an important word within the definition of intelligence. And apply can have many definitions in itself, but from a very broad perspective, apply means to take one thing and then use it another. I'm applying this word from here to here. I'm applying this medicine from here to here. I'm applying this law from here to here. So apply means to take one thing and then to use it in another context or in another scenario. So if we bring all of this together, if we say that language is about structure is about intentionality, and intentionality is a form of intelligence, then we can bring all that together and say that structuring is the display language, which is the structuring of words in an intentional way, is an intelligent act, because what it involves is the application or placing of words within a certain structure to achieve an impact. So there's a strong relationship between structuring as an intelligent act, which involves the application of words in certain places. So language is an act of intelligence because it involves the structuring and placing of words, the applying of words in a certain order. So what am I building up to here? If language involves the intelligent placement of words within a sentence or a paragraph in order to achieve impact, and Iraq is use of language, then if you put those together, then Iraq also must involve the intelligent and structured application of words and the placing of words. So if a law is about language, Iraq is the process of law. Iraq is taking the language of law and moving it through processes, and language is a structured phenomena that's intelligent, and ergo by definition, Iraq itself is an intelligent process, and it's about the placement of words, which I assume that all lawyers would agree with, because when you're involved in the industry or practice of law, what you're doing is you're taking the words of law and you're structuring them and putting them within a particular intelligent order to ensure that you achieve the best impact on behalf of your client. So Iraq is the intelligent and structured application of words, and I think that lawyers can all associate with that. Strong link between language, law, structure, intelligent placement, and Iraq. So if we accept that Iraq is a language in itself, it's the use of language within the process, and that language involves structure, intelligent structure, then it's a small step from that to identifying the optimal patterns or use of language that will achieve the best ends to be achieved for clients. So a client walks in to an office one day, says that something's happened to them, words. The lawyer then takes the words of law, combines it to what the client has said, language, structures that in a particular way to achieve the best ends for their clients. That's an intelligent structured process from which patterns can be discerned in order to work out what is the best way to achieve the best end for the client. I hope I've communicated that as clearly as I can do. So if we accept that Iraq is an intelligent structuring of words from which patterns can be, optimal patterns can be discerned in terms of how words are used and placed and structured in order to achieve the best sense for clients, there's a small step from that, identifying patterns within words, to artificial intelligence, which ultimately rests upon patterns. So lawyers display intelligence in the way that they take forward their client's case for language, patterns, success rates, analytics can be identified from that. Lawyers can say, well, this pattern worked well in the past, I'll use this pattern now. And they might then repeat that same algorithm in the way that they do their practice. And it's a small step from that, lawyers learning from reflection, to then taking that, drawing out patterns which can then be used to build AI-based systems. So let's delve a bit more into what artificial intelligence then is. And here the Google definition of artificial intelligence is the theory and development of computer systems. So the Google definition of AI is the theory and development of computer systems able to perform tasks normally requiring human intelligence, such as visual perception, speech recognition, decision-making, and translation between languages. So there we have the definition of AI, which pretty much seeks to mimic what it is, mimic what the intelligence that humans display by way of machines. Now we can look at a bit deeper into how computer systems, how AI systems function. So we can look at, for example, the movement of particles, electrons, active for different circuits and wiring, activating switches within chips, then resulting in sort of binary systems, your zeros and ones to display, to enable programs to be built, applications to be built, which can then enable large inputs and outputs and activation. I'm not going to go too much into the relationship, sort of the ontology of what computer systems are in terms of electrons and circuits and then binary systems and then digits and then digital and then building up towards programs and applications and systems and intelligent systems and then the activation thereof. You can, I think you can see the connection between those. So that's a bit looking a bit more into I guess technical matters. But what I would like to do is dwell a bit more upon the meaning of artificial intelligence as the mimicking of human intelligence by machines, and just drill a bit more into that aspect of it. That machines are all displaying the same sorts of things that human intelligence displays. Because if we accept that the definition of AI as mimicking human intelligence, then if machines can display human intelligence-like properties, there's a small step from that human intelligence to what we've argued up until now, which is then the language of law. If the language of law is the structuring the intelligent structuring of words into patterns to achieve impact. If what lawyers do is that they take words and they intelligently structure those words in order to achieve maximum impact for their client, and machines can also replicate that form of human intelligence, which of course, as we've seen, they can do. For example, through things like Alexa and Echo and other NLP systems. Then we move from that to, well, actually what machines can then do is mimic that human intelligence displayed in the structuring of language, and we can then apply that within the Iraq process so that machines can take the language of law and optimize it within the spaces of Iraq, within the taking of instructions, rules, application, conclusions. So machines can help us by the language of law in each of those quadrants. Because we said that that system was ultimately about a movement of words, and the intelligent movement of words, so that machines displaying human intelligence can also help with that movement of words. And then we can see how that enables algorithms to be built, programs and rules to be built to enable those machines to achieve that structuring of language, legal language, in the most optimal way. Algorithms can be built to enable that to be done in a way that benefits lawyers. It enables data sets to be identified and trained and inputted to ensure that that process is optimized for systems of, for example, machine learning. And it also enables front-end tools to be built, which can help lawyers do their work. And those algorithms, data sets, and tools that are built to enable machines to intelligently structure and use the language of law can rely on different input systems. They can be based on visual perception, they can be based on speech recognition. So you might be able to build something that can take human speech, a lawyer talking to a machine, which can then be translated by the circuits I mentioned before, activate algorithms within, and then work to what happens in Iraq and the language of laws and display intelligent-like properties. So you can see how that system goes around. And this can all be packaged and presented in a way that's both friendly in terms of user interface and also friendly in terms of user experience. So you can see how that cycle kind of goes around. You want to build something that has maximum user impact and user experience by way of, say, speech recognition or by way of written text that maximizes algorithms, data sets, and tools that enable the intelligent use of the language of law within Iraq and displays ultimately intelligence-like qualities in taking a client's case forward as you kind of working around either forwards or backwards in that particular diagram. So we return back to what we said at the very beginning, that the process of law here known as Iraq, as I presented it to you, can be viewed as the movement of words or language at the very outset, where clients provide information to their lawyers, which then commingles with the words of law as rules, which are then mashed together for analysis, application, advancements, and advocacy, in order to then ultimately come out with a conclusion at the end, which then benefits the client. So you can see that red line is the movement of language and words for Iraq. And that enables, by way of algorithms, those intelligent tools to be built that ultimately work through different forms of language. So for example, chatbots can be built which use, for example, natural language processing algorithms to enable clients to understand, and lawyers to enable actors within the system to engage with these chatbots in order to find information. You can have e-discovery tools. So if Iraq is about the movement of words across those four quadrants, clients providing information, evidence through to conclusion, and the words are moving across in different forms, and they're being structured in different, intelligently structured in different forms to achieve impact, then what programmers can do is look at the patterns within those structures that might maximize success and build tools, intelligent tools like e-discovery tools, to enable those patterns to be discerned and documents them to be indexed, ranked, and filed according to what would optimize the success in that particular case based upon past successes. So e-discovery ultimately enables those intelligent structures to be used to build tools, predictive analytics. So if, for example, you have a set of lawyers who in the past have achieved successes in cases based upon the use or application of words or evidence, or they've taken the case forward based upon certain back matrices or patterns, and they've succeeded, then what the machines can do is look at that data, identify those patterns, and then predict future success rates based upon the ways in which that data or the way in which the used language was structured in order to achieve success, so that can be used by way of predictive analytics. And of course, contract automation, which again is about the intelligent use of language, completion of templates based upon what the client's needs are. So what we have there with the red line is the movement of words and language of law throughout the system, which can then be looked at from an intelligent structure perspective in order for those AI tools to be built and mimic human intelligence. Ultimately working to the language of law. This is all good from one perspective because it enables efficiencies. So for example, rather than lawyers having to spend hours, days, months, whatever amounts of time on for example, discovery and having to read through masses of documents and then index those documents and then having to then send those documents to the other side, etc., etc. Of course, if machines are able to crunch through large data sets and documents quicker, that enables efficiency and cost savings. We've seen how technology enables collaboration across different departments, and ultimately might, one would argue, from an ethical perspective, help promote the client's best interests if, for example, the best technology is being used to take that case forward. But there are also a number of risks associated with the use of AI within law, and these risks have been well rehearsed, and I'm sure that many of you are familiar with them. So let's just summarize some of these risks for this particular presentation. So the risk of bias. Bias is the privileging of one perspective to the detriment of another perspective when there might be justifiable reasons for doing so. Of course, there might be positive bias, but there might be negative bias as well when there's an unfair prejudicing of a certain position in favor of one position as opposed to another when there might be incorrect reasons for doing so. And as these systems are being built, then of course they're being built to certain rules and certain algorithms by which one discerns that this particular way of doing something is better than another way, and that might amplify, that might work to a particular bias. And if the machine then itself is unable to discern what's right and wrong from a moral perspective, then that bias might then be amplified, both within the algorithm, but also within the data that's being fed into the machine to train it. So there's a risk of bias entering both at the algorithm stage of when the system is being programmed based upon certain combinations of what words are and different programming, and ultimately reflects what's right and what's good, and also within data sets that have been brought in to train that machine. We've seen instances of bias occur before, certainly within profiling. And it might be the case that companies are reluctant to allow their proprietary algorithms to be unpicked, and for those then to be challenged because they might have invested a lot of money within those particular programs and algorithms, which might be protected by patents and so forth. So then what that raises the issue is ultimately black boxes, the extent to which courts and others should be allowed to go behind and sort of unpick the ways in which those programs are being developed, because it might be proprietary interests and not revealing that. So one's striking a balance between different competing interests there. There might be confidentiality issues in the sense that if if, of course, algorithms rely upon data sets, and the data that's being fed into these systems, to what extent might a business client or other clients, for example, be willing to let their information be used, their confidential business information be used in order to train these algorithms? So that's something we'll come on to as we look at LLMs in a few moments. And of course, the data that's being used and kept in order to train these algorithms, where is this information being kept? Is it being kept in ways that ensure security? And so that if there were a hack, that there would be no way for this, this confidential information and data that might prejudice the interests of a client from being disclosed. And so what security systems are in place, what penetration and other forms of testing are in place in order to ensure this data is protected? Do machines act in the best interests of clients? Some might argue that what enables a lawyer to act in the best interests of a client. I mean, we find best interests of a client, of course, in different ethical codes throughout the world. Legal ethics, the primary duty of a lawyer is to act in the best interests of their clients. And one might argue that what makes human lawyers better to do that is that they have judgment and subjectivity, empathy, and other characteristics that machines just can't display in the same way that humans can. So therefore, can a machine display judgment, empathy, and other qualities that a human can? And can it act in the best interest of the clients? Can it empathize with the client, for example? Equality of arms issues might arise. So if, for example, you have two sides and one side has access to the top technologies and others do not, then what does that say for justice and the equality of arms and achieving parity and fairness within a case? What if something goes wrong? Where does liability lay? Does it lay with the client? Does it lay with the lawyer? Does it lay with the person who created the system? How do we then decide where if something goes wrong, where blame ultimately rests and where liability should arise? And might that impact upon liability insurance and the relationship and the terms and conditions between those who create these systems and those who ultimately, the end user, and those who operate them? So you can read up on these are common risks that are very well rehearsed and written about when it comes to the use of AI within the law, and by all means you can read up on those. And indeed, those issues would exist even if there was no AI, and hence, you know, if I go back a screen, then issues of bias and confidentiality and cybersecurity, best interests, equality of arms, etc. These exist irrespective of AI, and you know, that's why we have legal ethics and why lawyers have to subscribe to and learn about different ethical codes. But in the case of machines, do they somehow change and amplify those risks and bring a new layer that everyone needs to be cognizant of? So what I presented to you today is the language of law. What is language? Words and structure. So what is language? Words. So let me go back to the very beginning and summarize before I break. So I presented the language of law as a model. Giving you a definition of language, language consists of words. Within a system of law, Iraq, words move intelligently through those different processes from start to finish to achieve a conclusion. But language is not just about words, it's also about structure and the intelligent structuring of those words to achieve impact. And if structuring is an intelligent act, then if machines can display intelligence, the machines can also work to those same structures, and they do, by way of patterns, by way of data patterns and machine learning, to enable tools to be built which mimic that intelligent use of language by way of algorithm, to enable certain tools to be built which rest upon language sets such as e-discovery systems and predictive analytics and contract automation from the perspective of language. There are many different perspectives from which these tools can be examined. And indeed, language might not even be the right one. And I might have given a very broad approach to what language is. But I hope it works because it then becomes relevant for what follows in the next section, which is us looking at large language models. So I'll pause there, and I appreciate I've been talking for 1 hour, a long time. So let's take a 10-minute break, and let's come back at so it's right now it's 7 o'clock in Lithuania. Let's come back at 7:15. So I'll see you guys in 15 minutes. Thank you very much. 15 minutes, please. Okay, good evening, everyone. We'll resume in a minute. So if you'd like to get ready, we'll get started in a minute. Okay, so let's resume. I hope you all managed to grab a coffee. This second and final session of the presentation should last about 25 to 30 minutes, if not slightly longer. And then I'll be more than happy to take any questions and answers that you may have. So in the first session, I introduced the relationship. Bear with me a second, please. I introduced a relationship between the language, the law, structure, intelligence, artificial intelligence, and tools. And in the second part of the session, I'll go through large language models, generative AI, and the law, drawing upon what I introduced in the first session. And just by way of recap, language of law is an interesting model. And just recapping what I introduced to you in the first session by way of methodology, I began by saying that language, the definition of language includes words, and law can be seen as words, and therefore a form of language in a definitional sense or methodological sense. And that law, as words, as language, works its way through the Iraq process in a structured and intelligent way, because structure and intelligibility are elements of language. And this can be copied or mimicked by AI, which is the mimicking of human intelligence by machines, in order to build tools that work to language, and tools such as e-discovery, prediction, and contract automation, working to the rules of language and patterns and structures within what optimizes language use. So those are the chain of 8 that I presented to you in the first session by way of language. And in the second part, in the final part, I'll be looking at structuring and programming for the purposes of large language models. And I begin with looking at language and the brain, because large language models generally work to neural networks and mimic structures within the brain. So therefore, I think that in analyzing or looking at large language models, looking at how the brain functions in a very basic form in the time that I have, and how that then translates into large language models is something that might have some utility. So I'll essentially do that right now. So in the first session, we looked at the relationship between words and language and the way in which we understand the world through different modes of language, and how we interpret the world and our action within the world in intelligent ways and navigate the world by way of language. To give you a very basic example, we of course attach the word rain to the phenomena of rain and umbrella to the object of umbrella. So there are two words on the screen before you right now that are attached to things in our universe, within our world, rain and umbrella. And then we then draw connections between those words and a structure between those words within our heads, so that if it's raining, we might seek then to use an umbrella. So there is a connection, of course, between rain and umbrella within the way that we act and the way in which we perceive the world, the way in which our brains function. And this can be articulated by way of a couple of propositions. So the first proposition might be, it may rain, which is an input, and I will therefore take an umbrella, which is an output. Versus proposition 2, it may rain, input, and I will not take my umbrella, output. So in both scenarios, the input, what we see and perceive with our senses, or what we perceive might be the case with our senses. We see a grey sky with our eyes, and we assume input-wise that it might rain, translates with following a thought process within our mind into two potential outputs, that I will take an umbrella versus I will not take an umbrella. A very basic connection between two words or phenomena within our lives. So, well, a very basic neurological level, what comes into our mind when making that decision as to whether we should or should not take an umbrella? How does that process actually work from a perspective of neurons? Again, a very simplistic model. So it might work something like this. And again, this is a very basic model. So we have the input on the left-hand side of the screen of rain. We look at the sky, we see grey skies with our eyes, and we take input into us that it might rain. The next step in the process would be, well, factor certain things come into our equation, into weighing things up. What is the probability of rain? Then another thing might be, well, what's the availability of an umbrella? What's the proximity of an umbrella? Do I have an umbrella? Is it close to me? Is it upstairs? Is it in my car? Is it at my office? What's the availability and proximity of the umbrella? And then, okay, it might rain 20, 30, 40%. The umbrella happens to be in my car, but then I've got to take into account, well, it's not just those two things. There might be other factors. I'm going for a job interview, and if I don't take an umbrella and it rains and my clothes get wet, I won't make a good impression. So three very basic things come into the equation. There might be many, many, many more. So what we then do is we weigh up those three things on the basis of that input and then come up with an output. Should I take an umbrella or not? But there's a bit more to it than that, because in rationalizing in this way, we of course assign weights to different factors. So the probability of rain might be, okay, sky's grey, the weather forecast said it may rain, it's a 20% likelihood of it raining. So I'll assign a pretty small weight, 20% to that probability of rain. But then when I'm thinking about, okay, it's going to rain, where is the umbrella? Well, it's not to hand, it's not close to me, but it's in my car, which would entail me then having to go get my keys, go to my car, unlock it, get the umbrella out, etc., which in the scheme of things might be a slight inconvenience, but then I weigh that inconvenience up against the probability of rain. So at the moment, 20%, the umbrella's in the car park a fair distance away. I don't think it really justifies it. But then I might weigh the fact that, well, listen, if it rains 20%, if I don't have my umbrella and I gave way to that inconvenience, and it does rain and my clothes get wet, then it doesn't really look good if I go for an interview. So therefore, that carries a lot of weight, because I want to make a good impression. So therefore, when you look at those factors, and you assign different weights to them, then the output might be in favor of taking the umbrella versus not taking the umbrella as we weigh up those different factors within our minds. And it's something a bit more to it than that, because that's not just a one-off occurrence. That thought process is something that we go through hundreds or thousands of times throughout our lives. It might be that I once went for a job interview and I didn't take my umbrella and I got wet and I didn't get the role. So therefore, next time I've learned that I definitely should take my umbrella if I'm going to go for a job interview. So life is made up of these inputs, the weighing up of different factors, assigning different weights, and then learning, having feedback loops built in by which we then reinforce and learn as we move forward. So it's a feed-forward process that goes on there as we learn and reflect and build upon things that we come across and build upon life. So what we have within this very basic model of understanding are different factors. So we have inputs and outputs. You can identify with the input of rain, identify with the output of taking the umbrella. We have within this very basic model, not just inputs and outputs, but we have other data points. So we have that it might rain, being data, the probability of rain based upon my perception of the sky, the weather forecast, the newspaper, speaking to friends, etc., etc. So we made different data points as to the likelihood or probability of rain. We have data points as to the availability of an umbrella. Do I have my own umbrella? Do I need to ask a friend for an umbrella? We have the proximity of the umbrella. How far is it? Is it close to hand? Is it 1 meter, 10 meters, 500 meters, a mile away from me? That's obviously a data point. What am I wearing? My clothes, job interview. How important is a job interview? Who's interviewing me? The likelihood of them perceiving me to be bad. Is it an informal job? Will they laugh it off? Or was it a different sort of job where they, they might take it more seriously? So again, data points. And then of course the data point of the umbrella itself. Am I using an umbrella? Am I using something different in order to just cover myself? It could be take public transport, for example, take a bus. So what we have within this very simple model is not just input and output, potential input and output points, but we also have within this model data points. And there might be many, many, many data points within this particular model. We also have within this model factors or nodes, NODES nodes, that enable us to reach a decision. Now I've given you 3 potential nodes there, which are probability of rain, availability of and proximity of umbrella, and where I'm going. But there might be many, many other things that come into the equation in making that a particular decision. So there might be lots of different nodes that can be weighted accordingly in ultimately reaching that decision. And then we have within that decision-making model weights. So how much are we weighting something? If we have 3 nodes, weights might be simple. If we have 1,000 nodes, or 2,000 nodes, many different parameters and other elements, then we might have to attach many, many more weights. And those weights might need to be trained based upon different data sets to enable optimal outcomes to be reached over time. So not only do we have nodes themselves, but we also have different weightings that attach to those nodes based upon different combinations of phenomena and data to enable us to reach that decision. Then we have the feedback loops, whether we have a feed-forward loop, whether we have a feed-forward system working to data, working to loops that enable learning and reinforcement to occur. And so that was obviously another key part of the model as well. And what we're building up towards in many different ways, although it might be a very simplistic model, is something tantamount to an artificial neural network. I do stress there's a lot more to it than just this, but this is a very broad way in which it might function in terms of inputs, outputs, data points, nodes, weightings, and loops in order to facilitate that decision-making process. Now, one thing that I haven't given much attention to, because it might be a bit technical and I really don't have the time today to go into it as such, is, of course, the programming language. What is it that enables this entire mechanism to function, especially in terms of algorithms and probability and so forth? And there are many different AI models out there in terms of regression models and other forms of analyses working to statistics and different formulae and programs which enable this to be built. For example, one such methodology within large language models or generative AI are generative adversarial networks, which explain the way in which different data sets are brought together, for example, by a couple of competing data entries that enable those generations to be made. So one thing I haven't addressed within this particular presentation is I haven't gone too much into the programming languages that sit behind this model and make it function, certainly by way of statistics and other algorithm models that might be used. But I think you kind of get the idea about how artificial neural networks ultimately function based upon things like inputs, outputs, nodes, and weighting and so forth. But how that all came about in the very beginning was through phenomena within our world or things happening within our world to which we then attach words, and then words by which we make understanding of things. Of course, there are billions of words that we come across throughout our lives, and then the way in which our brains then connect and process those words in order for decisions to be reached by way of nodes and data and weightings and so forth. It's a very sort of complex process, which might, of course, also involves feedback and reflection. And within those artificial neural networks, it's not just about a few data points such as rain, availability, proximity, job interview, etc. There is a tremendous amount of data that goes into artificial neural networks, the phenomena of big data being crunched and algorithms being trained on big data sets to enable those systems to be optimized for ideal decision making. So what we ultimately end up with is big data, and then big data being pushed and trained across those different systems in a myriad of different ways to enable billions of potential outcomes based upon weightings and the different complexities that might exist based upon many different data points. So you can have billions of outputs depending on different forms of weighting and input. And those billions of data points within those large language models or neural networks, of course, enable many different outputs by way of text in sort of large language models like GPT-4, for example, and images as well. So you might have seen generative AI systems that can generate images based upon inputs. So there's different ways in which those billions can then be translated into text, images, sounds, and so forth to generate. So ultimately, what you end up with is, please excuse me, what you end up with is sitting behind it are neural networks programmed to big data sets by way of systems like GAN, generative adversarial networks, and other systems that can then generate billions of outputs and generative methods depending on what's inputted, how that's then processed across billions of parameters into many different outputs. So you can really have lots of outputs given the amount of data that's fed in. And if we then place that model of neural networks, big data, and billions of potential outputs onto a language system such as Iraq, where words and language are passing through the processing systems of law, if we then interlace those two together, you can then see the massive potential that large language models have for the system of Iraq and the system of law. And this can enable tools to be built. So already we're seeing many people, entrepreneurs, startups, law firms, etc., thinking about and experimenting with how large language models working to billions of points of data like GPT-4 and other forms of generative AI, how they can be used interlaced on top of law and its processes, its language processes to enable different tools and systems to be built. And that's already a very fruitful area. Just this morning, we were talking about it with someone, both Paulius and I. So many companies are now looking at how large language models can be used in law. For example, it might be the case that someone goes to court and systems can pick up language and maybe advise that person on what to say and how to represent themselves, through to lawyers sitting within an office who, for example, might type in something to their system and the machine is intelligent enough to say, well, this is what should be done. So these systems, companies are already experimenting with these different systems. And if you do a simple Google search of GPT-4 ChatGPT law, you'll see the different initiatives that are going on right now across the world to bring together these generative AI systems and legal processes together in order to automate or render tasks more intelligent in terms of the way in which they're carried out with efficiency and savings and use of technology. So they certainly enable efficiencies, these AI tools, and so therefore that's something to keep in mind. The application of these neural networks, these big billions of data points, and the ability to generate novel answers to questions and interlacing that upon the system of law as a language is obviously, there's lots of benefits to it, certainly in terms of efficiency and savings. But there's also problems that come with it as well. And some of these problems, they mirror some of the issues we came across before when we looked at artificial intelligence. So data privacy. So if, for example, somebody is typing in if someone is typing in a problem into a piece of generative AI in order to come up with a solution, then they need to recognize that in many cases that what they're typing in might be something private to them, but then it might be used to then train that data set. So it's going into a training set, which trains the machine by way of machine learning. So they're depending on what they enter, there might be data privacy issues. Of course, the GDPR would apply, but it's important to read the terms and conditions of any system that's being used when it comes to data privacy. Intellectual property is so a person might have some IP. The question that they input into the generative AI might be representative of their IP, but at the same time, what these systems are drawing upon are large masses of data which might be freely available through sources such as the internet. And those sources they're drawing upon might be protected by IP. So the question becomes, to what extent should these systems be allowed to make use of things that are protected by intellectual property? And I know that many jurisdictions are looking at the extent to which such data that's made available through the internet companies should be allowed to use them, and there should be certain IP relaxation of IP laws when it comes to the use of this data for the purposes of building these machines. Confidentiality. So if, for example, a client discloses something, a business secret, to a lawyer, which is confidential, should the lawyer then be using that business secret within a system, which ultimately then might take that data for the purposes of training it? Might business secrets be disclosed? Certainly things that are kept confidential or should be confidential. We already dealt with bias, so there might be bias within the systems, and there might be things known as hallucinations. You might want to Google and check up on what hallucinations means. That often when these machines are sort of coming up with answers and there are gaps, rather than identify, well, I don't know that there is a gap in the situation, then they might just seek to plug that gap with something that doesn't actually exist. So it might hallucinate and come up with something that's not factually correct. Cyber attacks, so if data information is being fed into these systems, certainly at a local level, then how secure are we that that data, that information is going through, is anonymized and is protected by different systems and prevented against cyber attacks? And what if something goes wrong? If someone types in a question into these systems and gets an answer back that they then seek to rely upon, if something goes wrong, who bears the blame? Where does liability rest? Does it rest with the programmer, or does it rest with the person who trained the system, who input their data, the person who used it? So there's issues around liability that also arise. Complexity and time is an interesting thing. Some of these generative AI systems, for example, are limited in terms of what information you use, for example, in terms of only going as far as 2021, and they might not be trained to the most recent data. And to what extent can they handle complexity? It's an interesting question. Now, what is on the one hand, you think, yes, they can handle complexity because they are trained to large pieces of data, big data, and therefore should be able to come up with solutions to very complex issues. But complexity doesn't just exist of factual things, objective things. It also consists of things that are a lot more nuanced and subjective. So, for example, you might have a situation that involves a family law matter or something that's quite personal, that involves highly emotive and subjective issues. That might be a complex issue, not simply because of what's going on, but also because of the way in which people feel and what they want. So can machines do that emotive complexity and empathy and subjectivity and those sort of softer things? Are machines able to handle such complexity when it comes to more emotive and human matters, which then touches upon subjectivity and subjectivity in judgment and aesthetics? What does it say for legal education? Already there's conversations going on about the extent to which people might use these generative AI systems in order to produce essay answers and answers to other legal issues. So what does it mean for legal education? Now, there's two sides to this argument, or actually there's many sides. One side would say that these systems are becoming part and parcel of our lives, so it's only right that those who go into legal practice and who will have use and access to these machines should be allowed to use them as part of their legal education. The other side argues that lawyering is ultimately about judgment, and that what we're doing is testing we're relying upon the judgment of a lawyer to act within the best interests of a client. That's the very nature or sine qua non of a professional relationship, that a professional has trained over a period of time, acquired skills and judgment, and therefore we're trusting that individual first and foremost and not the machine. And therefore, when it comes to legal education, them doing things for themselves and by themselves is a very strong aspect of them developing that judgment, and therefore they shouldn't be allowed to rely upon these machines and should be exercising using their own judgment and their own personal skills. So there's two sides of it when it comes to legal education. I'd be very interested to hear what side you come down on. And there's the acceptability issue. So some have said that from an ontological perspective, these machines will never, ever be human. And so from an ontological perspective, there might be acceptability issues in that we will never 100% abdicate responsibility to machines that can never, ever be human. So there's an ontological argument there, an ontological gap as to whether there'll ever be 100% acceptability and trust. I should have mentioned trust there, trust when it comes to these machines, because they'll never be human in the full human sense from an existential ontological perspective. So again, I've just touched upon some of these issues very briefly on this slide, and you could take any one of these issues and type them into a search engine followed by LLM, and you'll come up with many academic articles on them. But I wanted to make you cognizant of some of the questions that are arising with regards to large language models, especially in the fields of data privacy and also IP and confidentiality. So what emerges from large language models are a series of questions that I've identified on the previous screen, which can also be termed risks, but there's other questions which I'd like to pose for you now, a set of questions, and I'll leave these questions hanging in the sense that it might either be questions for you to go away and think about yourselves, or if you wanted to have a discussion on these questions following my presentation, which will end shortly, I'll be more than happy to have a debate or a dialogue with you on these questions, but I'll be very keen to understand what you think of them. So the first question is, what is the law? I mean, so if I go back to the very start of my presentation, I said to you that law is a language model, and what large language models, what artificial intelligence systems have done is they've worked to that model of law as a language and enabled tools to be built to allow those systems to be done more efficiently. But that raises a normative question as to what, certainly a normative question as to what the law is. If we take a natural law perspective and ask ourselves what the law is, then it comes with certain moral prescriptions, it comes with moral reasoning, notions of what's right, what's fair, what's just, what's wrong. And the question then becomes, to what extent can a machine do what is right, what is fair, what is just, what is wrong, etc. So are we, with the use of these machines, pushing law to more of a positivist law as opposed to a natural law? Is it changing what our perception or understanding of what the law is a question. It then also raises questions as to what is complexity. Going back to what I said before, there might be factual or objective complexities based upon data that machines can do well, but how about emotive and empathetic complexity when the complexity has emotions and other things attached to it because of the people involved, and to what extent can machines do that? Is there a risk with these machines of complexity being totally objectivized and becoming automated, and what it means to be humanly complex becoming diminished is a question to consider. Another question to consider is, what is a lawyer? So I guess this goes to the heart of the question. One of the questions I'm often asked is will these systems put lawyers out of a job? Well, it's an interesting question because on the one hand, machines will be able to do certain things well. However, it might change what it means to be a lawyer. Will lawyers need to learn coding? Will lawyers need to become more intelligent when it comes to use of machines and how they're used? Will they need to incorporate them within their systems and processes? Will we see more robot lawyers emerge in the future? Or will there be certain complex areas of complexity and judgment for which we will still require lawyers? So maybe what it means to be a lawyer in terms of skills will change. And it's something to think about. I'm more than happy to have a discussion on that in questions and answers. What about professional ethics and best interests? So nearly all legal codes place the client, the customer, the person whose services are provided at the core, and a lawyer's responsibility is to deliver the best services to their client, to act in the best interests of the client. But who is it that must act in the best interests? Hitherto it's been lawyers, but as more and more alternative legal service providers and technology companies enter the environment, is acting in the best interest becoming more dispersed and more fragmented? Must those companies then act in the best interests of clients too? Is it simply a professional duty that rests upon the lawyer? And can machines do best interest? If we go back to what we were saying before, can machine do norms? Can machines understand good, right, wrong, and what? And best, some might argue, is a normative consideration. Can machines do normative reasoning? So can they act in the best interest of the client, or is it something that only a moral agent can do, like a lawyer? What is acceptance? Will we ever accept machines can do things as well as humans can, given that machines, by their definition, can never be a human? So this goes back to the ontological issue I raised before, that will there ever be 100% trust in machines, given that there is an ontological gap between a machine, what a machine is, and what a human is, and the two will never be the same thing. What is Iraq? What does it do to the processes of that Iraq process, information, rules, application, conclusion? Does it change that entire system? Might we see some of that system fall away, so that at the information stage, rather than a client having to give instructions or evidence to a lawyer, they simply fill in a form and they send that form into the lawyer? Right now, conveyancing, for example, buying and purchasing a house, a lot of that has now been turned into forms and automation, and the need to see a lawyer is diminishing because a lot of it's done through the submission of paperwork, rather than having to see a lawyer face to face at the I stage. How about the rule stage? might we reach a place where lawyers no longer have to research relevant rules, and all they do is speak into a system, and the system itself can then identify the relevant rules for them and then minimize what they need for research. So what would it do to Iraq? And I've touched upon this. What does it do to the normative language of law and what we hold to be good, bad, right, wrong? I can say there, what does it do to justice? Is there a difference between algorithmic justice, human justice? Do the two come together? Can they be the same thing? A normative question. So certainly large language models are great in terms of time, efficiency, access, availability. There's a whole host of benefits that arise from these machines. And that's why lots of companies are rightly considering them. But if I go back to my previous screen, they also raise a range of questions that need to be considered, and also a number of risks and other issues that also need to be addressed as well. So there's a balancing act that goes on between the two when it comes to large language models. So I said I'd be half an hour, would be the second session, half an hour to 45 minutes. Well, I've actually taken a little over 30 minutes. And I'm going to come to my conclusion. Very happy to address questions and answers. I hope that you've found my presentation today to be of interest, and I hope that I brought together what law as a language and large language models in a way that's comprehensible, and it's answered a number of your questions. But I'd be more than happy to now have questions and answers. And certainly one of the key questions I'm asked is, will large language models put lawyers out of a job? So if you do have any questions, please feel free to ask. I'm really, really grateful to you all for listening to my presentation today, and I hope that it's answered a few questions for you. So please do feel free to post any questions in the chat section. Speaking, I see that a similar question has just popped up in the chat section. So if you don't mind, I'll just take a read of that question, and then I'll see the extent to which it overlaps with yours, and I'll address both together. So question from Ivan. Thank you very much, Ivan. Thank you very much for your presentation. I have a question about how the law for artificial intelligence should look like. Should it be vague and flexible to allow various interpretations, or be sufficiently precise? For instance, in the draft EU AI Act, the notion of a hybrid system is used, which is rather vague. Which approach do you think is more preferable? I would tend, and I think this is very similar to Paulius's question around risk, and certainly the EU's AI Act takes a risk-based approach, and it's a very genuine question to ask as to whether how tightly we should define and interpret risk, or whether we should keep it as broad as possible. I think that there are a couple of interests that need to be balanced here. And I think that this is mentioned also within the preamble to the EU AI Act, which is that, of course, regulation only exists for public protection. So the whole aim of regulating an industry is in order to protect interests, consumer interests, and other interests. And so therefore, it's very important that in the use of artificial intelligence, that we do think about the public, given some of the dangers that I've outlined, for example, bias, profiling, and profiling within employment, profiling within the justice system. So it's important that in order to ensure that people are treated correctly, that these areas are regulated. And risk obviously is an important factor there. But the other side of the equation is that what we don't want to do is we don't want to stifle innovation. There's a lot of benefits that AI can bring, especially in terms of efficiencies, savings, and improving well-being and improving consumer choice. So for example, we've seen in many areas of life that AI is being used to aid people in making choices, and indeed it's also being used within industries such as the medical quite well, very well in fact too. So I come down in favor of having a broader approach, because I don't think a restrictive approach benefits either the public or those who are working within innovation. It also doesn't help lawyers, in the sense that taking a very restrictive approach would stifle innovation and stifle advancements and progress that might better human life. that in turn would have a detrimental effect on the end user and on those who, the public who ultimately might benefit from these systems. And it might also create a minefield in terms of the law. So for example, with cases and other things having to go to court in order to resolve these issues. So I think that adopting the notion of risk is a good approach because it allows for the balancing of those different competing interests, or not competing, different complementary interests of ensuring that the end user is protected, that they get the benefits of latest innovations, it encourages innovation and progress, and it also ensures that the law can act fluidly when it comes to these systems as well. So I come down in favor of a broader approach. Thank you for the question, Ivan. I hope I've answered your question directly.
Yeah, thank you very much. Maybe I can ask one more question.
Yes, please.
Related to the same AI Act. There were a lot of debates on definition of artificial intelligence, and you mentioned one of definitions. There are quite a lot of definitions in different acts, not talking just about EU, and that's related to your answer, not a question, but an answer, that this regulation, can be useful or dangerous in some cases, or harmful for innovations. So how do you think, is it present last definition of artificial intelligence is balanced enough to regulate correctly the relations related to artificial intelligence?
Sure. So I think that it's, again, there are indeed many different definitions of artificial intelligence, but yet, although there might be different definitions, they ultimately have some commonality between them in recognizing that they work to large data sets, that they mimic human intelligence processes. And so at the core of them, they all speak to a very common definition, although there might be differences around the edges. What I think this points to is a couple of things, which we also see, for example, within crypto regulation, that the international community needs to come together and talk about this, not at the regional level, but at the international level when it comes to different definitions. And I know that UNESCO, for example, has done some very valuable work within the field of AI ethics at the supranational international level. But what we need to try and avoid is arbitrage when it comes to definitions, that one region or one state has a different definition to another, a different region. So what that will ultimately do is lead to arbitrage and lead to regulatory arbitrage and the fracturing of that definition. So whilst I see commonalities in definitions, the differences in definitions, which might be justified because different states might be approaching it for their own reasons from different ways, it also ultimately risks fragmentation, and we need to have that sort of overarching approach, maybe in the future, a treaty or something which moves beyond soft law.
Thank you very much.
No problem at all. Thank you, Lucas. Are there effective models and methods for implementing learning systems for generative artificial intelligence in the field of law? I'm not a programmer, so I really don't. I personally don't go into to deep levels of programming, etc. But I can certainly talk to ethical codes, and there are lots of ethical codes out there that, for example, lay out what programmers should be thinking about when it comes to developing systems. So, for example, a very prominent code that you might already know about, that you might want to read up on, is responsible AI. And the responsible AI code, for example, says that when those who are building systems are doing so, they need to think about, well, things like what's in the public good, so that they're not simply building systems without thinking about social and public goods, and that there is, for example, that built into it. And then you have various ESG codes, for example, that talk about, well, when these systems are being built, what are their environmental, social impacts, which again ties into responsible AI, so that when companies are developing systems, they are conscious of the ethical aspects that go into the building of these things. So whilst I can't talk, and I wouldn't want to talk to how programmers, when they're programming out, because I'm not a programmer, I can talk from the ethical perspective, and there are many studies that are being done within, when it comes to AI ethics, such as responsible AI, that set out very good parameters when it comes to the development of AI. So is there a code of ethics that should guide the government? So yeah, do have a look at good responsible AI. Thank you. I'll go to Katerina's message, which is a longer one. There is a Twitter account mocking people afraid of new technologies. They often mirror the most prominent risks voiced by posting an article 50, 70, 100 years, or when the electricity or modern cars are posed as a deadly threat to humankind. But still, all those inventions were rather substitutes of physical power, but not the mental. Shall we allow technologies to go this deep inside a creative part of our identity? And shall we use the cost reason we build AI to help poor people get access to legal services, as in do not pay case in Supreme Court, to continue the privacy harming practices of exchanging their privacy for developers' benefit? Wouldn't it be useful to devise rules and won't it be used to devise rules and lock us into options that a developer and training data provide us and replace the freedom of our will? Or is general good prevail over general evil for now? There's a lot within that particular question, really valuable points. And I'd like to address one within there, which is the extent to which we risk becoming robots ourselves, and we sort of abdicate what it means to make that decision-making process to machines. So one of the arguments that's often leveled against companies that use big data to inform choices is that, you know, it robs us of our choice to make our own decisions for us. So, for example, if I want to be able to be free to choose a particular holiday or a particular TV set or computer, then really that thought process should be for me to make, rather than having simply getting a notification saying to me, well, here's 10 things you can choose from, and here's 10 reasons why you might wish to choose them. There are benefits to that, certainly in terms of efficiency, but they also risk minimizing and encroaching more and more upon what it means to be a human decision maker, and it risks automating us. If we think about for example, what a robot is, of course, there are many different definitions of what a robot is, but a robot is an object which is programmed with a set of programs or different sorts of rules and processes, and acts upon that programming in order to reach a certain conclusion. So then what then becomes a dividing line between what it means to be human and what it means to be a robot? If more and more these decisions are being made for us based upon information that we're being provided for, and our ability to decide for ourselves is ultimately being diminished more and more, then don't we risk losing that sense of what it means to be human and end up becoming robots ourselves? I find there's an interesting parallel here, and some of you might be familiar with like Jean-Paul Sartre's work, a very famous existential philosopher. And when Jean-Paul Sartre, for example, spoke at his Paris lecture about what it means to be a human being, and he then compared humans to, for example, with a knife, that a knife is someone has an idea as to what an ideal knife should be. An ideal knife should be sharp to be able to cut, and then they produce that knife, and then the knife is ultimately made with that purpose in mind, and we judge that knife according to how well it performs that purpose. But the same can't be said for humans, in the sense that humans aren't made with a purpose in the same way that a knife is made for a purpose. And therefore, when humans are acting, they're not acting towards a purpose, they're acting by their own free will. But if more and more we begin to lead our lives by technology, and even the decision, for example, to have children or not comes down to economic decisions, we should have children because it's affordable or not. You know, I'm being a bit extreme here, but do we risk that domain of what it means to be human, free will, and that purpose ultimately becoming defined, and us becoming more robots? And we see that happening now. For example, you go to a restaurant and you see couples and children and others on tethered to their mobile phones, not really engaging in conversation. So it raises important questions, I think, from a multitude of perspectives as to what it means to be a human being. Again, I hope that I've answered your question, which is a really interesting question. So thank you very much for that. Lucas, how can generative AI help identify and resolve legal challenges related to patent and trademark law? I think that kind of generally goes back to what I've been saying about the language of law. If law is a language, and so patent law and trademark law is a language, and that language that enables us to reach certain decisions and outcomes for patent and trademark cases based upon the way in which we then structure and argue that law. And there's a small step from that to generative AI, which then works upon large language models and patterns within law, and then it can then spot optimal answers based upon the way in which the law is ultimately structured. So let me give you an example. I typed in to a generative AI system the same question. I said, I live in New York, full stop, and my neighbor is playing loud music and I can't sleep at night and it's damaging my health. What can I do? And then I typed in the same question. I live in London and my neighbor's playing loud music, it's damaging my health, and what can I do? So the same question, but I just changed the first sentence. So I said, I live in New York, I live in London. And it was phenomenal, the answer it came up with in terms of the legislation and the laws in New York City for noise nuisance and for damage to health, and what it came up with the answer in London. So it could really drill into different council provisions, different noise nuisance acts, different ways in which to take that issue forward based upon respective jurisdictions, because it's able to draw from those large data sets available via public and other sources, although it's limited to 2021. So I don't see why it can't do that. That being said, there might be certain subjective elements when it comes to the judgment of patents that it can't do, but it can certainly do a lot of the back-end work. No need to apologize for bad English at all. Absolutely none at all. Can AI be regulated by AI and make decisions for AI? Interesting question. So it's an interesting question because it goes back to one of the points I touched upon before, that regulation is ultimately about protection and protecting a group of people. So that's why that industry needs to be regulated. You wouldn't need to regulate something if there wasn't a risk or danger. And that risk or danger needs to be a risk or danger to a particular set of stakeholders. And that raises the question as to, is this a danger? Is this bad? Is this good? So when we're regulating, we're asking ourselves, do we consider this to be right, wrong, bad, and good, which are normative questions? And I guess the question you're asking about can machines regulate is, can they decide on what's right, wrong, good, or bad? Do they have that capacity to do so? Or does it always have to be a human that comes before, who's programming what's right, what's good, and what's wrong? Can machines decide what's right, what's good, and what's wrong? Is a question I'd ask. Can machines do norms? Be very interested to. So if I can ask a question to make it a bit more interactive, can machines do justice? Can machines be just? Was that Lucas? Is that an answer to the question? 99%. Can machines be just? Lucas, do you want to come on and maybe answer the question in person? It'd be lovely to hear your voice.
Good evening.
Good evening, Lucas.
Okay, is my voice normal?
It's
yeah, so recently one of my colleagues did a presentation, and in America there was one of the first big squads of related to the law, and they tried to fight AI in speed against dealing with law issues and so on, and like all the students, all the humans were affected from 60% to 8%, and it took like 1 hour to like accumulate all the data and be ready. And computer accumulated from 80% to 90%, and it did that in in a couple of seconds. So that's why I said like probably in a couple of years it would be 99%. And
so, but can a machine decide what's right and wrong for itself? So we know that generative AI generates answers, new content based upon data. Can a machine do what's right or wrong? Or are we saying that ultimately its decision of what's right and wrong must come from a human being who's programmed it? Like, so it's an interesting question, because if I decide that, say, for example, something really stupid, drinking 5 glasses of water is bad. Yeah, because it messes with your system. I'm giving you a very stupid example. Because I happen to have read somewhere, let's say I read somewhere in a magazine that drinking 5 glasses of water is bad for you. And then I see someone drinking 5 glasses of water, and I say, well, that's bad for you. Who's actually made that moral judgment? Is it me, or is it the magazine that I read it from? It's made a moral judgment. Because
it's collective knowledge, and it's perception of truth, and probably from that collective knowledge and all the data might AI would collect, would make that decision for 99 or 9% of the justice that would be made. I view as a justice as like a board of chessboard. There is many ways to achieve the justice for the person, and there is some kind of fight as well. And all the data that they have previous, AI could decide more effectively and have good understanding of real justice in particular cases.
So there's a collective, but just going to the question that I asked. I mean, so if I said to someone, if I read somewhere that 5 glasses of water are bad for you, don't drink it, is that my moral? Is that me saying that is that my decision that I think it's wrong, or is it the person who wrote the article? Well, this is an interesting analogy here, that if a machine then decides that, if a machine said to someone, don't drink 5 glasses of water because it's bad, is it the machine that's making that judgment of what's right or what's wrong? Or is it the data that it's been trained with by that human that did it, that's the decision maker? I think that's an important question, because then I think that goes to whether, if we have robot judges in the future, if I were to go up before a machine in a court, and a machine then said to me that, look, what you've done is wrong, so therefore pay a fine, would I be willing to accept that a machine can make a judgment as to what's right and wrong? Or do we want judges to be humans? So can machines do what's right and wrong and what's just, or is it ultimately the person that's programmed that's doing it for them?
I assume that it would be just for a machine to decide it, because lots of court cases make really bad decisions. Of course, there is issues, but I would definitely trust AI to make like low-level decisions.
Why not high level? So
it's more escalated probably in a court.
How about in a murder case? Judging whether someone committed a murder. Why do we have a jury system in some countries? Why don't we just let a judge or a machine decide on whether? If the facts are there, if the facts are there, if the CCTV camera is there, if there's medical evidence, then really, why do we need human decision makers? Why do we need a jury or a judge? Why can't we let a machine decide?
Because there's unique situations, and people lie even in court.
So can't a machine pick up what's lying and what's not lying? So what I'm
I see what you're saying now.
So it goes back to the acceptability issue. You could have let's imagine we're 10 years in the 10, 15, 50 years into the future, with the most sophisticated human-like machine in the world. Would we ever accept that it could ever be judge, jury, and executioner in a case? Would there ever be that level of acceptance?
But I assume there is no escaping from that, and in the future we will have these things, and AI will judging other AI and administrating other AI.
Okay, thank you. Paulius, I see that you're smiling. What are your thoughts on the issue as an expert?
I think we will use artificial intelligence more and more in the judicial system. I think in some now in some let's say less important cases, less complicated cases, artificial intelligence is used quite, you know, in China. There are some intentions to use in other countries, maybe not in EU. EU is very conservative here. I think we are not going to do it just due to regulation and our perception of the issue. But technically, it's absolutely possible because when we talk on application of rules, I think technologies are not so bad here. And when you asked, is it possible that artificial intelligence will understand, are you lying? I think there are technologies which are better than humans who can understand from your face, your attitude, your gestures, and you know, other small movements. Is person lying or not? But that's our issue. Do we trust and do we like to accept such a way of decision making? But that's related to a lot of areas. We were working on war, artificial intelligence used for military purposes. Do we like that some technology will kill somebody just without any human interaction, without any human? That's, you know, it's more philosophical question. That's not technical question. Technically, I think everything is possible, and within 15, 20 years, that will be not a problem at all. It's humans' problems. It's our problem. It's a regulation problem.
Yeah, I absolutely. I think you have to distinguish the technical from the philosophical, and also indeed from maybe the evolutionary. That, in a sense, that what history has shown us is that we always have these. I think someone alluded to. We always have these systems of advancement. So in feudal, industrial, technological, but people always adapt to those different systems. And I was reading an interesting article about how when email first came on, there were so many many discussions about how email would ultimately just destroy human life. But look, we've adapted to it. It's now, we don't even think about it, right? So the thing about human beings will always adapt. And I think Katerina has alluded to this in her message. I can see the transformation of a lawyer from a person who translates the law to a person who oversees the compatibility of a particular with the pace of society and change of times and circumstances in a particular decision so criminal lawyers will always have a job. So if we replace the word transformation, I can see an evolution of a lawyer, or adaptability. We will always find ways to evolve and adapt with technology. And so that's especially because of the complexity of life. And it goes back to the fact that there'll always be emotive and human complexities that a machine can't do in terms of judgment and relationships and what it means to be a human. And I think that emotive complexity is something that a machine maybe can't do in the future. But you're absolutely right. It does raise a philosophical questions, but I think applied philosophy more than abstract philosophy. Any other questions? So with that in mind, I'll maybe just call it to an end there, to say